counsel, you received all discovery. Did you review that with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Tamayo, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did, and I would like to address the court so I can just let you know what I'm doing in Texas. I'm from California.
Okay, I mean,
It ain't gonna make a difference.
all right, then maybe your attorney doesn't want to talk about what you're doing here. All right, counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Proceeding on count 2 waiting.
Any objection?
No objection, Your Honor.
All right, did you review the document entitled Court Admonishments and Defendant's Waivers with your attorney? Did you understand it?
Yes, ma'am.
Did you cite it in all the appropriate places?
Yes, ma'am.
Do you understand your charge of possession of a controlled substance, penalty group 1B, 4 grams to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Today, we've got a front row seat to what quickly turns into a courtroom disaster involving a defendant whose attitude is making things significantly worse for himself. From the start, his body language says it, all constant scoffing, rolling, rocking back and forth in his chair, and carrying himself with an obvious sense of arrogance. It's clear he's not taking the courtroom or the process seriously at all. One of the most important rules in court is simple. If you don't fully understand the legal process, let your attorney do the talking. But instead of staying quiet and letting counsel handle things professionally, this defendant seems determined to make himself the center of attention. Courtrooms are definitely not the place for attitude or theatrics. Especially when the judge is watching every move, judges have broad authority to maintain order and courtroom decorum, and behavior like this can absolutely hurt how someone is perceived throughout the case. Showing visible disrespect toward the person literally running the courtroom is rarely a smart move. It's basically like making your own situation harder for no reason. Watching this unfold honestly feels like seeing someone make one bad decision after another in real time. What do you guys think? Is this guy being openly disrespectful, or am I being too old school about courtroom behavior? Either way, let's dive in and see how this hearing plays out.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
I try not to, but yes.
Well, I mean, it's either you did or you did not. If you want a jury trial, we can set you for jury trial.
No, I just give up the rights.
All right.
Right?
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Tamayo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, but I would like to
Anyone?
tell somebody
Yes.
about you. I came to visit a cousin in July, and I was here only for a month. It took 5 months for me to see a court date. I lost my brother, I lost my cousin that I came to visit while I was in Kasher, lost my aunt, lost my sister-in-law too. And I was hoping for probation, you know what I mean? Go to Victory Outcry and get a blueprint and help out the community, give you guys a year and have the community speak for itself, you know what I mean?
All right. Well, what I can tell you is this is Texas, not California, and that's not the way things are done here. So my question is,
I also know what's constitutional,
anyone-
not constitutional.
has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Nah,
Anyone promised you anything other than the plea?
I just finished doing 10 years.
All right. Has anyone promised you anything other than this plea bargain agreement?
No,
Are you satisfied with the way you've been represented?
anywhere I can't complain.
All right. Are you a U.S. citizen?
Yes, I am. In
Court will find
California.
that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I understand it all.
According to the plea, state is proceeding on count 2. Punishment is to be assessed at 3 years in the prison. There's a $2,000 fine and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there being such motions?
No, Your Honor.
Then to the offenses charged in count two, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers state's exhibit number 1 and attachments.
No objection, Your Honor.
All right, you may be excused. Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
I signed a paper to get extradited. They said 30, 60, 90 days. Am I gonna get extradited back to California?
And then this guy casually tells the judge that he wants to be sent back to California, which honestly makes the whole situation even more bizarre. At that point, you almost have to wonder what his strategy is supposed to be. This is a courtroom, not a place where you can negotiate travel plans or casually request a different destination. Like it's no big deal, you can visibly see Judge Boyd's patience being tested throughout this exchange. And honestly, she deserves credit for staying. As composed as she does, it's clear she's doing everything possible to remain professional, despite the defendant making the situation increasingly frustrating. And then there's his attorney, who honestly looks like he's trying his absolute best to keep everything from completely falling apart. You can almost read the stress on his face while his client continues making things harder for himself with every unnecessary comment. This entire hearing is turning into a perfect example of what not to do in court. The defendant's attitude, body language, and overall approach make it seem like he's either intentionally pushing everyone's patience or just completely disconnected from how serious the situation actually is. Either way, it's definitely not helping him. At this point, the level of confidence and smugness is honestly hard to ignore. Let's see how much longer Judge Boyd can keep this hearing under control.
You're going to serve your time in custody in Texas prison, and then they will transfer you.
I thought I was gonna get extradited before that.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Oh, hell yeah.
All
I
right.
love Texas. Yeah.
Court will sentence you to 3 years in the prison.
Mhm.
There's a $2,000 fine, time and money to run concurrent. There's to be no contact with Sandra L. Torres.
Why is that?
All right. Counsel, is there anything else with regards to sentencing?
No, Your Honor.
All right, did you review the trial court certification of defendant's rights? And I'm sorry, also no contact with Julian Rodriguez
How do you know that, dude? I met him that day.
and Christy Brown. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain, counsel, did he review the document?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Good luck with you.
Do you guys think a 3-year sentence was justified in this case? What makes this situation even more surprising is that this defendant had only recently been released from prison, and now he's already heading back for another lengthy sentence. It really shows how quickly repeated poor decisions can lead someone right back into the same cycle. In many states, repeat offenders can face much harsher penalties under enhanced sentencing laws, including 3-strikes statutes in certain jurisdictions. Depending on someone's criminal history and the seriousness of prior offenses, consequences can escalate very quickly. In that sense, things could potentially have been even worse here, depending on the circumstances. What really stands out, though, is the defendant's attitude throughout the hearing. Instead of showing any real sense of seriousness or concern, he appears to be smiling, laughing, and treating the situation far more casually than you'd expect, given what's at stake. That kind of courtroom demeanor can leave a very strong impression. Judges often consider a defendant's behavior, attitude, and overall conduct during proceedings when making sentencing decisions. Showing a lack of seriousness, visible disrespect, or indifference usually doesn't help someone's position at all. It honestly makes you wonder whether someone like this will eventually recognize the pattern they're stuck in, or if they'll continue repeating the same mistakes. At some point, you'd think constantly cycling in and out of prison would become a wake-up call. But unfortunately, that isn't always the case. Anyway, that wraps up this breakdown. Let me know what you thought about this hearing in the comments. Don't forget to like, subscribe, and take care.